From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Donald Trump's first criminal trial could soon be back on the schedule after an appeals court rules he is not immune from prosecution. Plus, the Supreme Court is set to decide whether Colorado can kick Trump off the ballot as an insurrectionist. Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, columnists Kim Strassel and Alicia Finley. The judge in the first trial scheduled for Donald Trump, the case involving his attempts to overturn the 2020 election, had originally scheduled a trial date for March 4th. But that date has been pushed in part because of an appeal that Trump has made up to the D.C. Circuit Court of Appeals, arguing that the president is immune from prosecution, particularly for official actions that he takes while in office. Kim, this is an issue that has never been squarely decided by the Supreme Court, a novel one. And the panel that ruled yesterday says as much in its decision, saying that this is a novel question. But it answers in a sweeping fashion that the answer is no, according to this unanimous three-judge panel. It's an unsigned opinion. What do you make of this and the arguments that Trump is making, the arguments that the panel makes in response?
Well, to sum up what the panel said, and I think this is the key line of it, it says up at the top of the opinion, for the purpose of this criminal case, President Trump has become Citizen Trump with all the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. And there were some arguments that Donald Trump's team had made that weren't very sound as to why he was immune. Some of them were kind of silly. He essentially made the case that because he had already been impeached and acquitted in the House and the Senate on some of these issues, that he couldn't also be criminally tried for it. And the judges, the panel, I think, rightly dispensed with those arguments fairly quickly. The piece that you're talking about was the more substantive aspect of Trump's argument, which is this question about official acts. And I agree with you. I think that they didn't take those issues seriously enough, which will raise a big question as to whether or not the Supreme Court now decides to weigh into this. Essentially, what the court argued was that there are certain limits on this and that no man essentially is above the law. The president had pointed to the decision of Marbury saying presidential official acts can never be examinable by the courts. This panel decided to make a distinction between discretionary actions and ministerial actions, and we can talk about that a little bit more. But they essentially said that presidents are indeed subject to prosecutions. They also pushed aside, I think, what were some very serious arguments that the president's team that the opening of criminal liability for a president could get in the way of the ability for him to actually take occasional sweeping actions because of the fear of later prosecutions, being hit by a raft of debilitating lawsuits or prosecutions upon leaving office, and that this would chill presidential actions. They gave very short shrift to that argument as well. In essence, I would sum it up by saying that I think some of the arguments they made are worthy and interesting, but that they didn't really delve into the outer contours and complexity of this to a degree that the Supreme Court might want it to be done for such a consequential case.
One of the precedents to keep in mind here is a 1982 case called Nixon v. Fitzgerald. And this was a case brought by a government worker who was laid off, and then he argued in court that he was laid off because of political retaliation, that he had testified before Congress. The administration didn't like the way that he had testified. And what the Supreme Court said in that case was that the president has absolute immunity for official actions that are taken within the outer perimeter of his office. And here's the line explaining why they thought that: because of the singular importance of the president's duties, diversion of his energies by concern with private lawsuits would raise unique risks to the effective functioning of government. And so, Alicia, if that's the precedent you're looking at, there are two questions in my mind. The first one is whether or not President Trump's actions in the run-up to January 6, 2021, all of this stuff about these meetings of purported electors that were sending in purported certificates in states won by Joe Biden. But these electors were saying that they were the real electors and they were voting for Donald Trump instead. Whether all of that was official actions that would even fall under this Fitzgerald precedent in the first place. And the court could have said that that stuff is electioneering, that the president, if he gives the State of the Union before Congress and talking about his policies, that's an official action. But if the president gives a speech at a private rally talking about why he should be reelected, that's private conduct by a private individual who is running as a candidate. But this panel of the D.C. Circuit does not really get into that because they are declining to extend that Fitzgerald precedent at all. Here's what they say. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter, unquote. And one of the things that I think is interesting about that approach is that it does raise some questions. Are there official actions that a president could take that a future president or a future administration could decide are violations of the law and they want to prosecute, even though it's a president who's duly elected, who is telling the executive branch what his policy is that something that is prosecutable later on? And Alicia, the response by the panel is, I think, yes. And their defense to the idea that this is something that is going to happen often is that President Trump is the first one we've seen since the founding.
They actually even go further, and they suggest that this could actually be a benefit. The fact that they could be prosecuted in the future, that could actually deter potential abuses of power. The opinion says instead of inhibiting the president's lawful discretionary action, the prospect of federal criminal liability might serve as a structural benefit to deter possible abuses of power and criminal behavior. And it goes on to cite a 1982 case, Harlow v. Fitzgerald, that says where an official could be expected to know that certain conduct would violate statutory constitutional right, he may be hesitant. And here again, the D.C. Circuit said as well, that's actually a good thing, rather than deterring the president from actually conducting, official acts that are actually completely legal. It just deters him from committing illegal acts. But they didn't really square, as you point out, with what is an official act. If you recall, the McDonnell case over a decade ago regarding the Virginia governor, and it was a bribery case, and the Supreme Court overruled conviction, saying that the Virginia governor, in return for essentially gifts, didn't actually commit a quote-unquote official act. But the High Court hasn't defined official act. And it's potentially the D.C. Circuit might have been reluctant to wade into that, but instead they ended up just opening up this Pandora's box by saying that, a president could potentially be convicted for things that are within his job. I mean, obviously, I think we'd agree that if President Trump had gone out and shot someone on Fifth Avenue, he could be charged with murder, right? If he had done that in office. But let's say if he had ordered a drone attack, not in the U.S., but let's say Afghanistan or somewhere, and this caused injuries and deaths of innocents. And what has been happening in recent years is actually more and more you get these torts being brought in the U.S. courts rather than extraterritorial cases. And the result could be that the president wouldn't just be sued, but he could actually be charged down the road for this act that it was, most people would agree that is an executive action that's just completely discretionary. This would really chill his or deter him from actually taking what are completely lawful actions within his scope of powers.
Hang tight. We'll be right back with more on this in a moment. Welcome back. Kim, this ruling also puts the Supreme Court in an interesting spot because, as I said at the top, the trial was scheduled for March 4th. Judge Tanya Chutkin has now pushed that. But this ruling on lack of immunity by the D.C. Circuit now is about to restart the clock and put the case back in Judge Chutkin's court. So remember, it only takes 4 Supreme Court justices to hear an appeal. And so it raises interesting questions of whether there are 4 Supreme Court justices who either think that there are problems with this ruling or, at the very least, think that an important question that has never been heard before, whether a president has some kind of immunity for official acts, that the Supreme Court ought to have the final word on that and not this lower appeals court. But if the Supreme Court decides to take the case, then that stops the clock again, and it makes it more unlikely that this case would go to trial before at least President Trump is probably going to be nominated by the party as the presidential nominee, if not after the election.
We'd like to think that the court always makes these decisions based on the question of law, that all 9 of the justices would look at this and say, this decision was decided correctly or incorrectly, and regardless of timing, regardless of politics, we are going to take the case for that reason or not. Of course, as we all know, there are many different calculations that go into the decision on whether or not they grant cert on cases or take up an appeal. And in this case, I think one of them, as you note, is timing. Now, I would note that Jack Smith, the prosecutor in this case, has been pushing very hard to maintain that trial schedule of beginning on March 4th. And a couple of decisions about timing where he expressly said, we need to stay on this schedule because of the political ramifications of this, did not wash with the judiciary, which was good, by the way. We do not want to see the courts denying justice, as it were, because of political considerations. So I think that will be one thing. I don't think that it will necessarily be the deciding reason on whether they take it or not. My own view is that if there were an alternate consideration for why the court would take this, it's whether there are 4 justices that, if they think this case was decided incorrectly, there are also 4 who are brave enough to take this case, because it's yet the latest example of the court being asked to step into election year politics. As we already know, later this week, and we're going to talk about it, they're hearing this case about the Colorado suit and whether or not Donald Trump can be stripped from the ballot over insurrection claims. They might say, well, we could let this stand and dodge this bullet. But I think one of the major problems with this case is that one of the things the DC panel essentially did was say, we're going to allow these indictments to proceed because essentially men are angels and we have the safeguards of grand juries and the safeguards of the ethical obligations of prosecutors. This is why this has only happened one time in history and it's not likely to happen again. That's a really poor argument. Our entire Constitution was, in fact, geared the other way. It's supposed to set up a system to guard against the fact that men are not angels and that often politics gets out of control. So I think the risk that if they don't take this up now, it comes back to bite them and that they end up having to deal with this in future scenarios and future constitutional crises and moments of political upheaval that will be in part because of the court's making if they dodge it now.